Number 95, matter of Lacee L. Good afternoon, counsel.
May it please the court, Your Honor. Alan Schoenfeld for the mother, Stephanie. I'd like to reserve 2 minutes for rebuttal.
2 minutes?
2 minutes, please.
Very well.
Thank you, Your Honor. This court has long held that the reasonable efforts standard requires the petitioning agency to make meaningful and tailored efforts to reunify parent and child. As a matter of both state
Counsel, is it your position that the reasonable efforts standard in our state law is the same as the ADA reasonable accommodations, reasonable modification standard, or is there a difference?
Our position in this appeal is that the reasonable effort standard in a case where the parent presents with a disability covered by the ADA, the ADA substantive content is part of the reasonable efforts determination such that a family court cannot conclude that reasonable efforts have been made where ADA required accommodations are not made.
So the
Isn't
required
there a
ADA
situation
modifications
where
are
a permanency hearing looks at a snapshot of 6 months, correct? So is there not a situation where the agency learns about the parent's disability, connects the parent to tailored services, accomplishing reasonable efforts, but has not learned enough in the context of that 6-month period about the parent's disability to accomplish the ADA goal of reasonable accommodation?
So let me speak in hypotheticals or in generals and then about the facts of this case. That may happen in the course of permanency proceedings. The family court always has discretion to kick out the time as to which it'll make a reasonable efforts determination. Here, the period covered by the order on review was 9 months, for example. In this particular case, however, that's not what happened. At the first appearance before the family court, the ACS had a history with Stephanie. They understood that she had a cognitive disability. They understood that she had executive function difficulties and that decision-making following schedules was part of her disability. She had been in the foster care system. There was a prior case with her older daughter. They understood her disability. Accommodations were requested at the very first appearance in front of the family court. They were again requested, and that was in June of 2014.
Didn't the court order certain
The court eventually
modifications?
ordered them. That was on December 1st, 2014. But there were at least two.
And they failed to comply even with that order? Is that correct?
Absolutely. And you know that
They eventually got in substance all of the 5 specific accommodations requested.
not as a result of ACS's efforts, no.
But as a result of the court process, ACS provided them.
No, I think at least with respect to supplying her with the assistance to be able to fill out the Medicare forms that gave her eligibility for particular services and connecting her to the Office of Persons with Developmental Disabilities, that was all as a result of counsel. That was all as a result of the Bronx
Would
Defenders.
you just help me out a little bit with the timeline? When did the permanency hearing commence?
The permanency hearing commenced in June of 2014. Lacee was born on June 5th. I think the first appearance in front of the court was June 10th, 2014.
Okay, so that's actually from right from the beginning of the court's involvement is when the permanency hearing begins, or is that the time frame that the permanency hearing covers?
So I think the permanency proceeding might have actually begun before Lacee was even born.
I'm sorry, I don't mean the proceeding. I mean that there is at some point the beginning of testimony, hearing about reasonable efforts and what the permanency plan is and all that. I know there's court appearances, there's meetings, there's all this stuff going on continuously, but the actual hearing is.
I think the first date, and my colleague will correct me when I sit down, but I think the first date where testimony was taken on reasonable efforts was in September of 2014. So the child at that point was 3 months old. But there were appearances in front of the court in June of 2014, September of 2014. Counsel in the family court filed a motion for a finding of no reasonable efforts on November 20th, 2014, in anticipation of the party's December 1st appearance.
Did counsel assert the specific disabilities that her client was suffering from?
Absolutely. It was very clear to everyone, it's undisputed in the record, that her precise form of cognitive limitations, her executive functioning deficiencies were all made clear to everyone. And in fact, no, I apologize. Go ahead.
No, it's the proceeding with this child is actually subsequent to another child, and ACS has a history and familiarity with the mother. I just want to know, did they not know until counsel at this point gave them that information, that she had these cognitive
The initial
limitations?
intake notes for this case for Lacee's birth reflect ACS's knowledge of her cognitive limitations stemming back to the proceedings
Even
with her
before
older
this?
daughter. Correct.
Counsel, how would your rule work? So I think your position is if you violate the ADA, then it cannot be reasonable efforts.
Correct.
So how do you affect that in a family court proceeding without a family court judge essentially making a full-blown ADA finding?
In the mine run of cases, in the mine run of permanency proceedings, these issues are already part of the party submissions to the court. Even under the state's reasonable effort standard, unvarnished by the ADA.
But now we're varnishing it.
Sure.
So the ADA comes in and you say you haven't complied with X. And there may be a court ruling saying in this particular circumstances you have to do Y. And now ACS hasn't done Y. And you say didn't do Y, can't be reasonable efforts. We're done. You couldn't have made reasonable efforts here. And doesn't that take the focus away from the best interests of the child?
Not at all, Your Honor. So let me respond to one factual point, and then I can answer your question. There's no point at which, in these proceedings at least, the permanency proceedings are over. The permanency proceedings are ongoing. The finding that the court made that's on appeal here was that from the period of June of 2014 to March of 2015, the agency had made reasonable efforts. Our position is because they violated her rights under the ADA during that period, they had not made reasonable efforts.
And she would have to determine that during that period. At the end of that 9-month period, this family court judge would have to essentially make a finding as to ACS's compliance with the ADA.
As part of the reasonable efforts determination.
So would the court then apply ACS remedy, or excuse me, ADA remedies in that situation?
No, there's no
All right,
ADA claim. I
hold
apologize.
on. I don't want you to go too far astray here, because your time's going to be out, and I want you to address the jurisdictional issues that your opponents rely on. So go ahead and address those issues.
Should I address your first question first, or just
Go
the
ahead.
jurisdictional one?
Yeah,
So there's no ADA claim in this case. There's no counterclaim. There's no ADA cause of action.
Right. I am struggling to figure out how a family court judge can have jurisdiction to apply the ADA. I can see using them as a model, though it's difficult for me to see what the difference between the phrases reasonable accommodations and diligent efforts are, but okay.
I'm happy to explain that also.
No,
but
don't bother.
Let me address your
Let's just
jurisdictional
address the
concern.
jurisdictional question.
Sure. I think the jurisdictional concern here is misplaced, and I would remind the court that in Michigan Supreme Court's decision and
Well, there's the one Michigan case. Is there any other state, the Hicks-Brown case, I think you made reference to?
there's
Is there
Elijah
anything
C.
else?
from the Connecticut Supreme Court.
I'm sorry.
Elijah C. from the Connecticut Supreme Court. Both of those cases find, consistent with DOJ and HHS guidance, that family courts applying the reasonable effort standard have the authority and the obligation to determine whether the agency has complied with the ADA as part of their reasonable efforts consideration. So with respect to the jurisdictional question in particular, the court has jurisdiction over neglect proceedings. The court has jurisdictions to conduct permanency proceedings. As part of the court's jurisdiction to do those things, under Article 10 of the Family Court Act, they must make a reasonable efforts determination. ACS would not stand here and submit to this court that if the agency discriminated...
Let me stop you. What that sounds like you're saying to me is that New York law covers the concerns that the ADA would protect.
The ADA supplies a floor in the case of a disabled family. Part of the reason we are here, or the reason we're here, is because the family court in the appellate division held as a categorical legal matter that the ADA is inapplicable to these proceedings. So
Just to clarify, I thought in the first department, the position has been, and I thought they concede this, that the agency does have to comply with the ADA, and that whether or not it does is guidance in its reasonable efforts determination for that family court judge. Am I incorrect about that?
I think that's not the only reading of either the
Lacee?
appellate division case. So Lacee was an Article 6 case, and I think that's an important distinction that we can get into. But here, the court applied that rule in the context of an Article 10 proceeding. If I may,
Sure, go ahead.
apologize. So ACS's position in front of the family court was that the ADA did not apply, and in fact, that it would be unfair to hold ACS to its obligations under the ADA because it had no notice that those obligations would apply in the family court.
That's not its position now, though.
It's not its position now, but part of the reason they say that is because at that point in time, they said there was insufficient authority directing them to their obligation to comply with the ADA. And the family court said the same exact thing.
Let me ask this question. I don't mean to be rude, but you're running out of time. So
Sure.
how will this child be helped by us ruling that the ADA would apply and create a different standard? What benefit will this child get by our saying that this ADA standard would apply as opposed to New York law solely?
So let me answer that question in two ways. First off, we're asking for the same standard to apply. Reasonable efforts need to be made in every case. In the case of a parent with a disability, that requires reasonable accommodations. But to answer your question more directly, this court has made clear in any number of cases, Michael B., Marino S., Nicholson versus Capetta, Jamie J., the legislator has made a very clear directive that this court is obligated to follow. It is in the best interest of the child to be reunified where possible with their parent.
But what the ACS is saying is that the reasonable efforts tailored to the parent's particular circumstances is what achieves that end. And what is confusing me a little bit is that you're, and the Chief Judge alluded to this, you're taking a snapshot of a period of time. We're not to the end of this. We're a long way from the end of this, perhaps, right? And it seems to me that it is possible for ACS to be making reasonable efforts to get there. I mean, we had communication problems, we had all kinds of, the mother saying she was getting certain evaluations which were necessary to reasonably accommodate them. All sorts of things were happening here, and they hadn't gotten to the point at which perhaps under an ADA hearing, a court might say, okay, you've made reasonable accommodations. But they could still be making reasonable efforts to get to the same goal. And that's what concerns me, is that you're asking for the family court to make that determination before the time is ripe for that determination to be made. And it seems to me that then you're getting a trial within a hearing, and this is not serving the best interests of the child.
So let me answer that question in two different ways. The first one is ACS still hasn't provided the services that the court ordered them to provide, the accommodations that the court ordered them to provide in December of 2014.
That's sort of outside the record, and we don't know what the reasons for any of that.
Certainly. Well, as this record closed in 2016, and they still hadn't been provided, even though there was an order.
But that's a different issue. That's the failure to comply with a court order.
I think it is indicative of ACS's decision not to accommodate disabilities in the course of providing reasonable
At any time say, we
efforts.
need more time.
No.
They've never said, we need more time, and then we'll do it.
That's exactly right. And I think
They did say we haven't been able to do it because of these other problems, and they say that we were not informed until the eve of the permanency determination that the mother's problem was that she couldn't do these things on her own to get to the point where we could help provide her with the services.
So that's just wrong.
Well,
and we
that's a
understood,
fact-finding matter, but that's...
I think the record is clear on that point, that they were aware of her disability. They were aware that the request was for accommodations for her disability.
Yes,
but with respect
what exact accommodations is the question?
So, yes, and I also think in your question, the it there is a question. Is the it that ACS is obligated to do to identify for her certain services that accommodate parents with disabilities? Or, as the family court said, are they required to take her there and help her fill out the paperwork, which they never did? Under the reasonable effort standard, they should have done that. But with respect to the timing question, I think it's important to realize that in permanency proceedings, there's a retrospective dimension and a prospective dimension. At the end of a period that is the subject of a permanency proceeding, the family court needs to enter an order and say, during this period were reasonable efforts made. And they conclude the function of the reasonable efforts determination is to figure out whether ACS can propose a permanency goal that is other than return to parent.
But that goes right back to the Chief Judge's first question she asked you, which is, it seems to me, at least in reading the papers, and we'll ask him in a second, that ACS says there's no dispute that ACS must comply with the ADA as part of its reasonable efforts. And so the Chief's question is, do you have to do that every 6 months? And Judge Fahey's bookend question to that is, suppose we were to reverse here, what is the practical effect for this family of reversing?
Sure.
What will happen that is not going to happen otherwise? And when you keep saying that here there are orders that ACS hasn't complied with, that suggests something different. It's not the failure to comply with the ADA, it's the failure of ACS to comply with court orders that have been issued.
That's certainly right. Let me try to answer both of your questions. As I said, there's a prospective dimension to what the family court does at the conclusion of a permanency period. What they say is during this forthcoming permanency period, in order to make reasonable efforts, you need to do these things, and that's what's set out in the permanency order. There's a question of whether those things are the things that are required under the reasonable effort standard as ACS and the family court and the appellate division construe it, or those things also require making reasonable efforts as reasonable accommodations as required under the ADA. Our position is you cannot comply with a reasonable effort standard in the aggregate without complying with the ADA. The timing question, the periodicity of the family court's determination, the family court has lots of tools at its disposal to figure out when it is going to make those determinations. If there was a claim by the responsible agency that they were in the process of making reasonable accommodations in order to comply with the ADA, the family court could be responsive to that. That was never the position here. There are things that she asked for at the beginning of these proceedings in 2014 that she never got. On remand to the family court, just to answer your question, on remand to the family court, first off, this court should reverse the categorical legal conclusion of the appellate division and the family court that the ADA is inapplicable to these proceedings. Second, this court should reverse the family court's determination that reasonable efforts were made during the period of June of 2014 to March of 2015 because they did not comply with the ADA. Third, in making prospective permanency orders in this case, because the permanency proceedings are ongoing, the family court should direct ACS to provide the accommodations that are required under the circumstances. Those may not be the same accommodations that were requested in 2014, but now Lacee is 4 years old. Stephanie is trying to parent her. She's still in the custody of her grandmother, but Stephanie is making efforts to try to parent her. So for example, one of the accommodations that is very regularly offered in these cases is homemaking assistance, helping Stephanie develop a routine under which Lacee can thrive.
So how is that different from the reason, I'm still not understanding what you think the ADA adds to what ACS is already required to do to fulfill its obligations to this mother and this child.
Our conception of the reasonable effort standard is that it can never go beneath what the ADA requires.
So if there is a violation of the ADA, court holds a hearing, we say family court has the authority to do it, does the custody of the child go from the grandmother back to the mother?
No. There needs to be a determination about the disposition at the end of the permanency. Those proceedings are ongoing. Right now, the permanency goal is kinship guardianship with her grandmother.
I see.
But there's always a hope that she will be returned to her daughter. She only wants the opportunity to
The problem I think we're all struggling with, it seems to be more about the quality of the delivery of the services to a person who's intellectually impaired, as opposed to a legal solution that the ADA may or may offer. And I'm trying to find my way to say, how does this help? And that's what I'm struggling with.
The ADA says that when you exclude a parent from services that a public entity, a covered public entity provides, you are discriminating against them on the basis of a disability.
Might there not be other services that the ADA would require that wouldn't necessarily inure to the benefit of the child?
And if that's right, then they aren't reasonable under the circumstances. There are mechanisms.
They may be reasonable for this parent, but not for the child.
Isn't the reasonableness reasonable for the purpose, not the parent? It's reasonable modifications for the service, and the service here
Absolutely.
is the goal of reunification.
Absolutely. These are services in the service of reunifying the parent and child. And so the accommodation has to have some nexus. It has to be reasonable under the circumstances with the goal of reunifying the parent and the child. There are grounds under the
But I guess my question is, and I think I understand what the family court needs to determine, but if the mother brought a plenary action under the ADA, let's just say, okay? She could show that she, as a person, needed additional accommodations, okay, that maybe go beyond the services that she needs for this particular purpose.
But the correct respondent in that plenary action wouldn't be ACS. ACS is only providing services to her to the extent that she's enmeshed in permanency proceedings, where the services being provided are meant to reunify her with her child. So if she were asking for services like, I don't know, assistance with filling out a job, well, job application's a bad one because that may have a connection too, but if her services were, having physical access to particular buildings that had nothing to do with her ability to care for her child, that would fall outside the scope of the services we're talking about here. These accommodations are reasonable on their face because they go to ACS's ability to provide her with meaningful access to the services that the family court, ACS, and the parent have recognized are necessary to rehabilitate her as a parent and allow her to be reunified with her child, which is the goal of Article 10.
And I don't know how that differs from reasonable efforts
So
standard.
let me try again to answer the question.
I know you're saying that reasonable accommodation should be a floor, but that doesn't explain to me what the difference is.
So our view is that there is no difference, that reasonable efforts need to include the ADA because you cannot.
What is it that the ADA includes that the reasonable efforts doesn't?
I think the problem is that the case as it was framed by ACS and the family court recognizes a distinction between what reasonable efforts is and what reasonable accommodations are. The court found that reasonable efforts were made in this case during this period, notwithstanding the court's recognition that additional accommodations were warranted and yet had not been made.
Does that have anything really to do with the ADA, or does that have to do with what you are arguing is necessary to get this parent to the access to services she
The
needs?
only reason the family court identified for not ordering those services is because it believed that it was barred from considering her ADA claims or her submission under the ADA. The accommodations she asked for were tethered to an undisputed disability, were tethered to the particular proceedings, the purpose of those proceedings, to rehabilitate her as a parent and to reunify her with her child.
Well, let me ask it this way. If the ADA didn't exist, would you have been asking for the exact same set of services?
Absolutely. So the point is that the lower courts have misconstrued the reasonable effort standard to include a different standard for parents with disabilities. We think that the reasonable effort standard, with its focus on meaningful, tailored, individualized attention, is overlapping with the ADA. The problem is that the lower courts believe that there's an exception to the reasonable effort standard for parents with disabilities. And so they can find reasonable efforts, notwithstanding that the accommodations that are required under the ADA have not been provided
There
to the
could be
parent.
no circumstances then, in your view, where there is a violation of the ADA over this 9-month period, and the court could still find that reasonable efforts were made overall in applying the best interests of the child, looking at all the services and all the efforts that were made. One of these things may have had a violation. There should have been a reasonable accommodation made in some fashion, but that one thing then would mandate a finding that reasonable efforts were not made. The court would have no discretion in that case.
I think that the court has discretion about how exactly to sort of configure the permanency proceedings. If there has been a violation of the ADA in the provision of the services that ACS is obligated to provide.
One meeting, no ramp, person can't get in, but they have another meeting.
That's not a violation of the ADA. The case law is entirely clear that failure to provide a ramp one day, failure to provide an interpreter when you provide an interpreter next week, that's not a violation of the ADA. They caricature it as
Level
perfect
of
compliance.
interpreter. What about level of interpreter? Is that controlled by the ADA?
Level of interpreter, you mean for
Level
someone?
of skill.
I don't think so. I mean,
What if it was, then what, could you come in and say you didn't provide the level of skill, even though the evidence is that it was provided and they understood, but you didn't comply with the ADA's technical requirement of a certain level of skill be provided?
I don't think the ADA, as we say in our brief, and we cite ample case law on this, requires good faith, interactive negotiations between the responsible agency and the party. It doesn't require perfect compliance. It doesn't say you
And
failed.
the family judge would be ruling on whether there was a good faith interactive effort here.
Absolutely. That's the same inquiry that they make under the reasonable effort
So
standard.
what, again, does the ADA add to that?
If this court were to clarify that the reasonable effort standard requires making accommodations for parents that is meaningful, that grants them meaningful access to the services to which they are
Why
entitled.
isn't that the ADA can inform, or the other language used by some of these other courts, the family court's consideration of whether reasonable efforts were made? Is that
Because this case
you're
is
asking for?
evidence that that sort of direction to lower courts, in their view and in ACS's view, it makes it optional.
You've
It
never
makes-
said that, though. This court's never said that.
This court has never said that, no. But if this court were to clarify that it is a binding obligation on the lower courts to consider a parent's disability, make accommodations, and that is part of the reasonable effort standard, I mean, I think that is tantamount to what we're asking for. I think what the Michigan Supreme Court said and what the Connecticut Supreme Court said in their two decisions implementing or reflecting DOJ and HHS's guidance is the reasonable effort standard, which applies in all of the states as a result of AFSA, simply means that you need to make the sorts of efforts to accommodate disabilities that is expected in ordinary non-discrimination law. And so the ADA supplies the substantive content. Efforts are not reasonable. The Michigan Supreme Court and the Connecticut Supreme Court say this categorically. Efforts cannot be reasonable when you fail to do what a federal non-discrimination statute expects of you.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon. May it please the court, my name is Scott Shore and I represent ACS.
Where do you differ from the arguments that we just heard?
Based on the arguments I've heard this afternoon, there is not a lot of difference between the parties' positions. We agree that the ADA should provide guidance to family court in appropriate cases for determining whether...
Let me press you on the should provide guidance, and just tell me what you meant by the sentence that I read to counsel, which is at page 4, right under the heading of point 1 in your reply brief to the amici. There is no dispute that ACS must comply with the ADA as part of its reasonable efforts to reunify children with parents who are disabled. What do you want us to take from that?
Which means that if a parent believes that a foster care agency or ACS has violated their ADA rights, of course they can take ACS or the foster care agency to court and sue for a violation of the ADA. Or they can alternatively use the ACS accommodation and grievance procedure.
Well, the sentence doesn't speak to what, maybe this is all you meant by it, doesn't speak to what a parent may do, what right of action it has under the federal statute. It talks about ACS's obligation. Does ACS have an obligation to comply with the ADA?
Of course it does. The question here is whether a permanency hearing, which only normally looks back at 6 months of reunification efforts.
Well, is that where the rubber meets the road here? That is, if you were asking about the life of the proceeding, you would not dispute that over the life of the proceeding, you have to comply with the ADA, and failure to comply with the ADA is a baseline. It's just that in every 6 month or however long or short the snapshot is, you can't, is your argument that you can't sort of take the ADA's requirement and couple it with the 6 month period and turn that into a requirement that every 6 months there must be a determination of compliance with the ADA during that period?
That is exactly the point, Your Honor.
Is that the whole of your argument? Is that where the rubber meets the road?
That is a big part of the argument, Your Honor. But another part is that, well, of course, family court...
Well, nothing forecloses you from when counsel shows up at the hearing to say, we need more time. We're in the process of reaching compliance that we concede is our responsibility and obligation under the federal statute. Correct?
We said here that we said in sum and substance, we need more time. We said, the foster care agency said, we're exploring programs...
Is it ACS's position that you did comply with the ADA? Put aside the reasonable efforts. I'm just talking about compliance with the ADA.
It's our position that that issue was not raised in this case. We didn't have a burden to show that we complied with the ADA because no one was saying that the ADA applied to this 6 month.
So it's your position that you could fail to comply with the ADA, even though you acknowledge, let me finish, you acknowledge it is your obligation and duty to do so, that you could fail to comply with the ADA across the lifespan of the hearing procedure, and yet a court could conclude, as it did here, even though you say the ADA issue was not really resolved here, could conclude that the agency have made reasonable efforts?
We're talking about two different timelines,
No, we're
Your
talking
Honor.
about one thing.
The-
Is it possible for a court to find that you've made reasonable efforts even though you've not complied with the ADA? It's a yes or no?
Yes, it is
Okay,
possible.
then what is the
because
difference in that standard? Now I'm back to Judge Stein's question, I think.
Because-
What's the difference in the standard?
I believe Judge Stein had it right when she said, and I may be paraphrasing slightly, what is required at the permanency hearing, looking back at the last 6 months of reunification efforts, is the question is, did family court make reasonable efforts to provide the
Not family
accommodations?
court.
This is family court.
No, no,
I'm
but
sorry,
family-
I misspoke.
ACS.
Family courts, the question family court needs to ask is whether ACS and the foster care agency made reasonable efforts to provide the reasonable modifications to services that are required under the ADA. And that is.
In other words, reasonable efforts doesn't mean you achieved the
Right.
modifications.
And
But
that's-
is there some point when family court has to decide, you've been given enough opportunities to make these reasonable efforts, and you haven't achieved them, and now I say you haven't made reasonable efforts?
Family court doesn't have jurisdiction to adjudicate that ADA claim.
Why
If-
not? That's, I think,
Because-
the real question. Why
Clarify
not?
that question before you answer it for Judge
Of course.
Rivera. Is it your argument that if there's a dispute as to what the ADA requires under federal law, that dispute shouldn't be heard in the context of the permanency proceeding?
That's right, Your Honor.
Okay.
It would derail the permanency proceeding and turn it into a mini-trial to adjudicate federal rights, which family court doesn't have jurisdiction to do because it's a court of limited jurisdiction under the
But if
Constitution.
you're going in and saying, I need more time to comply, then you have some idea. So let me ask you a different question. What does ACS do when faced with a parent who has disabilities, who's eligible under the ADA to have services provided, meaningful services, so that they can achieve this reunification or attempt to achieve this permanency reunification goal? What does ACS do to identify the nature of the disability and the services that it will provide?
The ACS does, what ACS does not do, if I may start there, is impose strict ADA requirements. Does not say to the parent.
No, please, answer my question,
Okay.
not the one you wish I asked. What does ACS do? I just want to get a sense of your protocols and your procedure.
I know what happened in this case. What happened in this case is that the agency referred the mother for testing to determine what was the nature of her
At
disability.
what point did the agency do that?
It was, I believe, that it started before the permanency hearing began, which, to answer your earlier question, was December 1st, 2014. But it was starting to look for services for the mother even before it had definitive medical evidence that the woman had cognitive disabilities. It was looking at that Synergia program, found out that there was a Medicaid coordinator prerequisite, and started working with the mother and the Bronx.
And is that your procedure and protocol with respect to a parent with disabilities? Not just in this case, is that what ACS does?
My knowledge is of this case, Your Honor. I don't have knowledge of the full range of protocols. I would be surprised if it worked very differently in other cases when parents with disabilities presented themselves in permanency hearings. But the reasonable efforts standard not only applies to parents like the mother here, it applies to parents who don't speak English. The reasonable efforts would require a translator. It applies to parents who are using illegal drugs without getting treatment.
Can I ask you, is there anywhere in the record, and I didn't see it, so if you don't know, I understand, that points to an objective test results that establishes some basis for the mother's cognitive functioning? In other words, some test, somewhere I can look in the record, tells us what the results of these tests.
I'm not aware of that in the record.
Well, did ACS at any point in time challenge what the attorney said were her cognitive limitations?
No, Your Honor.
Do you know if the test was ever actually done?
I'd have to go back and look at the record. Nothing springs to mind as I stand here.
Okay.
But nevertheless, and that's an interesting point of distinction between applying the ADA strictly and applying reasonable efforts. if we were applying the ADA strictly, the parent would have to prove that she is a qualified person with a disability under the ADA. We didn't require that here. We started looking for appropriate services for this woman apparently before we had any evidence
Well,
of what her
sometimes
cognitive
in these
disability
things,
was.
it becomes ridiculous. So you've dealt with people for a while, you recognize they have the disability. Let's say it was a physical disability, like you were missing a leg. You don't need to send somebody and it may be a level of dysfunction here that it was evident that the lady needed the help, so.
But it wasn't evident in granular detail what kind of help she needed. It was only on the last day of the permanency hearing, March 15th, for the period covered in this case.
That's why I was wondering if there was ever any follow-up, if she ever actually had a test done and what the test showed.
I would have to look at the record. My colleague
Don't worry about
may be able to answer that
The
question.
court did order, right? Didn't the court order ACS to take particular steps that it didn't comply with?
The court did make orders, and the agency made reasonable efforts to comply. But things like securing a Medicaid coordinator, that is not within the agency's power to do. All the agency can do is help the mother get the documents together, help her present the package. Eventually, this woman was deemed eligible for a Medicaid coordinator. That's on page 801 or 804 of the record.
ACS informed the court that it was ordering things that ACS could not do?
I don't believe that those words were ever used, but we certainly said, or the agency caseworker said, I found out that we need a Medicaid coordinator. I discussed it with the mother. I discussed it with the social worker. Here's what we're doing to try to get those documents together. I reminded the mother on many occasions that she needed to get the documents, and I told the social worker that too. That was what happened during that particular 9-month snapshot. And eventually, she was found eligible.
And if counsel says you can't just tell her to do those things, you have to recognize that's part of the cognitive limitations. Let's use this hypothetical. You're informed of that, and ACS continues, nevertheless, to merely just tell the parent, this is what you need to do, knowing full well that the parent cannot function with that kind of instruction. Would that be if that's all you did, would you have made reasonable efforts to achieve reunification?
I think family court would be well within its rights to say, no, we did not make reasonable efforts. But the point is that can all be handled under the reasonable efforts standard. This court in Star A in the 1980s, before the ADA was even enacted, applied the reasonable efforts standard.
So I think you didn't answer, what's the difference between the two standards? I asked that before. I think you may have gotten interrupted in the answer. What's the difference?
Even my adversary has said that they are coterminous. It's not clear to me what is going to be required under the ADA that isn't already required under reasonable efforts. And courts have been.
So if that's true, then what's the objection to us saying that the court has to make this decision when it's deciding reasonable efforts that you've complied with the ADA? If they're coterminous, that's your position now?
Well, the objection is the jurisdictional objection. The idea that there would be a finding. The idea that there would be a finding without an adjudication.
If they're coterminous, that's essentially what they're doing.
Well,
I don't understand this argument. They're doing that anyway.
What we're doing, and what we suggest family court does, what it did in Lacee, what was endorsed by family court in the first department here, is to use the ADA as guidance. Not only guidance for whether reasonable efforts were made, but guidance about future orders.
The judiciary would have to understand the parameters and the law anyway, correct?
I think it wouldn't have to do the burden shifting analysis. It wouldn't have to try to figure out how ADA burden shifting fits in with the preponderance of the evidence standard that applies during permanency hearings. It wouldn't have to have an adjudication with
But what does it have
fast
to do?
discovery.
All the things it doesn't have to do. What does it have to do? What does that mean, guidance?
It can look at the Code of Federal Regulations. It can look at HHC and Justice Department interpretations of the regulations. It can say, according to these documents, this person needs these kinds of services. What have you done to provide?
Is part of what's mucking this up here that in the same breath, the appellate division in two different cases, Lacee, now this case, has said it can be used to inform, but it has no bearing, or it's not applicable. I mean, those things don't sit well in ordinary English.
I take your point, Your Honor. Based on the language of the decision in the First Department, when they cite Lacee, it looks like the First Department is taking the approach that the ADA can provide guidance to family courts. That statement that it has no applicability seems to go well beyond where it felt comfortable going in the rest of its decision. And family court used the ADA as guidance as well. It happened in Lacee. And other courts, like the Everett Court, have resolved issues like this without looking at the ADA at all. And I just want to close by saying that with respect to reasonable efforts, putting aside the ADA issue, before I get there, let me add that another problem with making everything contingent on a finding of ADA compliance is reimbursement, federal reimbursement for the expenses of the foster care services provided during the previous 6 months. We don't want to be in a situation where we find out in month 5 that the mother or the parent needs a particular accommodation. We just can't get it to her within that final month, or there's some minor shortfall in our efforts.
But then it's not reasonable, right? That's the whole point. There is some flexibility in this standard.
There is flexibility in the
If you need
reasonable.
more time, you communicate that to the court, and that's about the reasonableness
Right.
part of it, yeah?
That's fine, and that can be done under reasonable efforts without trying to engraft the ADA and
But
ADA
that's reasonable
adjudications.
modifications, I thought. I thought you're taking the position that you're obligated to comply with the ADA,
Right.
and that it's coterminous.
We are obligated to comply, but there should not be, and there cannot be, a finding, an adjudication and a finding of ADA compliance or
If
non-compliance.
let's say we disagreed with you. Let's say a majority of the court disagreed with you. How would you avoid the preclusive effect? I'm going to ask that to counsel when he gets up on rebuttal of that finding.
We would have to argue that the family court had no jurisdiction to enter that finding.
Is
But
that
if
the only way to avoid the preclusive effect?
we would
You
have
sort
to
of
say.
made a
we
whole
would- we
argument
would-
of
we
how
would
the
have-
court isn't going to do a full-blown ADA assessment.
We would have to say that our rights were not fully vindicated in that family court hearing because there was not a full adjudication. And of course, family court could not have conducted a full adjudication because it would derail the permanency hearing. It would delay the permanency hearing when the whole point is to achieve timely and effective review of the services that are provided. But if we were wrong and a court said that family court findings on ADA violations do have preclusive effect, well, then we're in a whole new world where every permanency hearing turns into a full-blown ADA trial, depositions, expert witnesses, and then appeals. The whole permanency process would become fundamentally different. On reasonable efforts, putting aside the ADA for a moment, under this court's decision in Star A, in order for this court to reverse on that ground, the mother would have to show that the efforts were unreasonable as a matter of law, and they haven't come close to showing that.
Thank you, counsel. Counsel?
May it please the court, my name is Andrew Baer, and I represent the child Lacee L in this matter.
So you're the attorney for the child. What benefit does the child who is the subject of this proceeding obtain from what appellant argues for?
Well, again, because I think that the standard is coterminous, as we've all, I think, agreed to here, and I think that the court even agrees at this point in time, there is no further benefit, in a sense, in applying the ADA specifically to the case. Services that they would have.
What's the consequence for the family if we affirm? What's the consequence if we reverse?
Well, I was going to actually address that.
Is there any difference?
Well, there really isn't. I mean, again, because we talked about how this is an ongoing proceeding. The only practical effect that would really occur is that the agency would not receive its federal funding for that period of time. But I mean, we are where we are today, and we can't go back and redo what was already done. Part of providing services to a parent is a process.
Well, you say that that's the only effect of perhaps reversing, but how does it affect later on when we get to the end of the termination proceeding? If we get there, where it has to be established by clear and convincing evidence that
Well, what's
there's been
interesting about making
compliance with reasonable
efforts is that it actually goes towards what the current goal is. If the goal is actually termination of parental rights, what they look towards is
No, I'm
what
not
the agency
saying
has
that
done
that's the
towards
goal. I'm
that
saying
goal.
that that could be where this ends up ultimately.
That is correct.
Right. And is there an effect on how that's going to get evaluated depending on what's been happening at these snapshots, if you will?
Well, but I mean, what's going to happen at these snapshots is the agency and the court is going to learn what further services are needed, what services may have actually been provided that are not giving the effect that they need to reunify the child and the mother, and that they need to go forward with further types of services that would allow that to happen. As an example,
I'm not so sure they are coterminous. Maybe they are, maybe they aren't. But if we find for the appellant here, they will be. So essentially, what we would be doing would be molding whatever our standard was, maybe it was coterminous, maybe it wasn't, to now be the ADA standard.
well, what I'd say just about that is the agency has admitted that, I'm sorry, the appellant has admitted that they are. But this court, of course, could make a ruling that was different than that.
What if we're not sure? What if any given circumstance, maybe there is a hypothetical where it wouldn't be? Essentially, my concern is, wouldn't we be removing from family court the ability to say, on all of these circumstances, and there may be some violation of the ADA, which could be championed in some other form, we're going to have to find that reasonable efforts weren't made, whereas under the prior state standard, we would have found that they were. And
Well,
that concerns me because I don't know if they're coterminous or not.
I understand. I think part of the problem, though, again, and that we discussed is where is the jurisdiction of the family court, to allow it to adjudicate an ADA claim? In this case, we had a
Counsel, but they're not making an ADA claim. Let me go back to something else that you said, because I'm not sure that I'm persuaded by the point you were making about what might be the disposition depending on whether or not we reverse. Could we not reverse and remit and simply say, the wrong standard was applied, go and apply the correct standard? You're incorrect to say, as a matter of law, a family court does not take into consideration, or cannot take into consideration, compliance with the ADA in determining whether or not reasonable efforts have been made. Now go determine, knowing that you have to decide whether or not they've complied with the ADA, whether or not reasonable efforts were made during this period of time.
Well, I think that then forces the family
And
court.
the court might come out with the exact same determination.
It might, but it forces the family court, I believe, at that point in time to make an ADA determination. And part of the problem.
Yes, but
part of the problem.
Counsel,
I apologize.
I just wanted to clarify this other point, that it's not necessarily the case. In this case, that ACS is going to lose its money. The court might decide, even now knowing that, yes, I can take into consideration, or I have to apply the ADA here and determine whether or not ACS has complied with the ADA, I believe that they've made reasonable efforts.
And that's correct. I think that they can do that. But the problem still, I think, goes to a larger question, and that is if the family court is making an ADA adjudication then in that sense and saying that they did comply with the ADA, where does the line get drawn to where that finding then can be taken? If a parent applies for a disability, then is it determined already that they're disabled and that there's been
Applies to who? I lost the thread of the
well, saying
point.
applies to the parent. In this case, there was a consent that this parent was disabled. What happens in the case where there's no consent between the parent and the agency that there is a disability? Again, then you're talking about the family court having to basically hold a full-blown hearing under, I guess, the mental health or mental hygiene laws to determine whether or not she is disabled. And then from there, obviously, you've completely disrupted the permanency hearing's purpose and goal. That's actually
But
what
don't
happened.
you have to do that anyway? If one party says, listen, I need these services, not anyone who's disabled, I need these services, and the agency says, you don't need those services, doesn't the family court have to decide whether or not you need those services? Look, isn't the whole point of the ADA to put persons with disabilities, in this case, parents with disabilities, on a fair, just equal footing with everyone else who doesn't have disabilities when they're trying to access services that the government is providing? That's all it's saying. She might not be able to parent. The conclusion from the court might be, you complied with the ADA, you made reasonable efforts, but she's still not able to parent.
The case law essentially, though, already...
Reunification is not appropriate
The
here.
case law essentially, though, already says that they must tailor towards that person's specific problems. And so I think...
So then the courts are already doing that. So I'm not understanding, other than the loss of money, which I'm not so persuaded would be the result, what it is that the ACS says the family court cannot do, if it's already doing that. If I understand Judge Garcia is not persuaded, maybe others are not, but let's take for the moment, if it is coterminous, They're already doing that. That's why I don't understand this argument
But
from
if
the
they
ACS.
are already doing it, then why does this court need to make any further ruling as to what they're already doing? They're already
To
complying with it.
clarify that you have a court saying we don't have to do it,
Well, I don't think that the court ever said here.
and says there's guidance and we don't know what that means.
Well, I think the court said that it should use the ADA as guidance, and I don't think the court ever said that it didn't know what that means. And I think that the courts in Michigan in Hicks versus Brown and the courts in Connecticut in Elijah C. further said the exact same thing, that it should be used as guidance, and that they were not going to go as far and say that this can be used as a defense in a termination of parental rights case.
I don't know, reading family court's paragraph titled "The ADA is not applicable to this proceeding," at least the way I read it, family court judge latches on the has no bearing language and then criticizes it, saying, essentially, I've got to follow this, but I don't really understand it because neither Chance Jamel nor Lacee has really any rationale, and there's no detail in the holding, but you know, I think it's confused by the language that the appellate division used.
Well, I just think that in a full reading of this case, along with those other two cases, that the courts did state, though, that the ADA rules should be a guideline. So I think that if you're not reading that in a vacuum, that the courts would understand that.
Let me ask you this on this jurisdiction question. I'm going to pose a different hypothetical. Let's say you have a parent and counsel who comes in and says, you know, and I'm not saying this is true, it's just a hypothetical, that ACS provides services in a way that it is discriminatory based on race. Are you saying the family court would not, when it's deciding whether or not reasonable efforts have been made, be able to decide that question? Because I don't see the difference between that question and the question here.
Well, I mean, I guess it's, again, the same question as a parent who comes in who he said is disabled physically, and whether or not, you know, when and what the accommodations the ACS would be required for that parent.
No, but now you're talking about figuring out sort of that factual issue. This is a different issue, right? This is about the jurisdictional question. If someone presents and says you're violating a core legal requirement, let's use Title VI, you can't discriminate based on race in the provision of services. A parent comes in at counsel and says that's exactly what you're doing. You're saying family court cannot make that determination in deciding whether or not reasonable efforts have been made?
I don't know that it can jurisdictionally. Again, this is a court of limited jurisdiction that was, you know, made by statute, and I don't think that it can exercise powers beyond what it is granted.
Okay, thank you.
Thank you.
Thank you, counsel. Counsel?
Judge Rivera, let me pick up with the last point you made because I think it's an apt analogy. It may be the case that the court could not hear a freestanding Title VI claim, but what the family court cannot do is bless with a reasonable efforts finding an agency's discriminatory conduct against a parent, and that's exactly what the agency is trying to do here. I think ACS's position before this court today obscures some real
Can I
differences
ask you a
between...
question I asked him, because I
Sure.
promised him I would ask you, about the preclusive effect. He's very concerned about that, and I too am struggling with this preclusive effect of a finding that, let's say here, a negative finding that the agency didn't comply with the ADA.
And I don't think that there would be any preclusive effect of a reasonable efforts determination that was predicated on some finding that the ADA had not
But
necessarily...
would it have some effect down the road if the agency then wanted to proceed to termination proceedings, and, you know, which they then have to prove by clear and convincing, and then depending on where it is in the snapshot?
That's certainly right. I understood Judge Rivera's question to relate to a freestanding ADA...
I think you did understand her
Okay.
question correctly. Mine's different.
Sure. So just to go to Judge Rivera's question, I think if someone said the family court found that no reasonable efforts had been made, and so I am bringing this ADA claim in the United States District Court for the Southern District of New York, there would not be preclusive effect. There is not a full and fair opportunity to air all of the aspects of the ADA
Well,
claim.
then how can the court make a determination that there's been a violation of the ADA?
Federal family courts make determinations, predicate determinations under federal law all the time. If you look at some of the
How does it
decisions...
not have preclusive effect? I mean, if you're saying it's not really a full-blown ADA finding, then what is it?
It is a weird animal, I grant that, but if you look at some of the cases we cited, there's one of the adoption cases we cited. The court needed to make predicate determinations about the adoptive child's immigration status to determine whether the best interests of the child were being met in that case. And they said sometimes adoption depends on questions of federal law. So too here, sometimes reasonable efforts turns on interpretations of federal law. There's another case we cite that involves the state's interpretation of the state provision of ICWA. And the question in that case was, is there a whole Indian family exception mandated by the Constitution to preserve the constitutionality of ICWA? That's a question that's been before the United States Supreme Court, and the family court considered that as a predicate determination.
But I think the statute specifically requires family court to
not to make a
consider that.
constitutional determination as to the federal ICWA statute. What it says is it can make determinations as to whether a parent is a member of an Indian tribe recognized under United States or New York law. It's a completely different question from the one the court entertained. I think one of the points that I want to leave the court with is what we are asking for as a matter of process is not different from the permanency proceedings that are conducted every day. Mr. Shore explained that, allowing the ADA to become part of this standard here would require depositions or testimony or experts. Happens in permanency proceedings all the time. There are always experts called in to discuss a parent's disability, to discuss the child's status, whether a particular permanency placement would be in the best interest of the child. These proceedings would be no different. It's simply a question of whether the family court is complying with the ADA by providing reasonable accommodations. I understand my time is up, but if I may, I just want to make sure that I address one final point. ACS has done a very good job on appeal of obscuring the difference between the parties. Before the family court, ACS argued as follows: there is no basis to superimpose the requirements of the ADA onto Article 10A as a means of evaluating reasonable efforts. Such an arbitrary use of a federal statute by this court would be ultra vires, not only because there is no precedent for same, but because ACS would have no notice that the court is requiring it to adhere to certain standards not contained within the text of Article 10A. ACS has been on notice that it is obligated to comply with the ADA for decades, and it does not comply with the ADA. It has no protocol to comply with the ADA. The availability of this ACS grievance process in ADA first came to our attention in the briefing of the appeal before this court. That's not something that any practitioner in family court has any ideas available. ACS needs to understand that it is obligated to comply with the ADA in providing reasonable efforts. And it needs to understand that the family court will not bless with a reasonable efforts finding its violation of the ADA in cases where a parent has a disability.
Thank you, Counsel.
Thank you, Your Honor.